Collazo versus Netherland property assets. Good afternoon, Counsel.
Good afternoon. Excuse me, I have a little cold. My name is Ronald Languedoc. I'm with Himmelstein McConnell for the appellants. I'm here with my colleague, Jesse Gribben. I'm here to argue today that the...
Counsel, may I interrupt you for a moment
Certainly.
and ask you if you would like to reserve some rebuttal?
Oh, yes, 2 minutes, please.
Sure.
The tenant's causes of action for rent overcharge should not have been dismissed based upon the doctrine of primary jurisdiction, nor should their cause of action for under the general business
I
law.
just want to be clear, though, now that we have the HSTPA, do we need to decide at all, if we assume, for the purpose of this question, that that is going to be retroactively applied here? Do we have to wrestle with whether or not, under the old statute, there was concurrent jurisdiction, it was properly dismissed, was it abuse of discretion to send it to the agency? Do we have to even deal with that?
Right. I don't think you do, Your Honor. I think the statute is clear on its face that the statute codifies the previously existing court-accepted doctrine that tenants had concurrent jurisdiction with the DHCR to pursue overcharge claims, and it's now makes clear, it's specifically in the law, that it's subject to the tenant's choice of forum.
So I'm a little confused then. Do you adopt what I understood the Attorney General, the DHCR through the Attorney General's position that, yes, that's true, but in certain circumstances, the court can indeed dismiss? Or are you taking the position that subject to the tenant's choice means if the tenant chooses to proceed in court, the court cannot dismiss it, although perhaps could seek guidance from DHCR? DHCR could submit
I think
amicus?
it's hard to, right, I understand the court's question, and I think it's hard to come up with a hypothetical scenario where a court would require that type of involvement. There is a procedure under the rent stabilization law where the court can certify a question to the DHCR. There are also proceedings which are known as fair market rent appeals, which are under a different provision of the rent stabilization law, which there have been, court decisions saying that the DHCR has exclusive jurisdiction over those.
Just to clarify, was that issue about the right to submit a certified question or refer back or anything like that, was that raised in this case in Supreme Court
No,
or in the arguments
no,
here?
No, it was not raised. I'm just.
So do we need to decide that?
No, I
Yeah?
don't think you
Okay.
do. I was just trying to respond to Judge Rivera's question as to whether hypothetically there could be cases where.
Well, I don't know how we don't get to it, given I thought, I will ask them, that their argument was that nevertheless, they fit within these exceptions. So if indeed the statute says, no, it's not quite the primary jurisdiction doctrine that formerly applied, then it
Right.
does make a difference.
Well, the statute now says that it's concurrent jurisdiction subject to the tenant's
Yeah.
choice of form, and nothing shall prevent the tenant from asserting a claim in court. So if you put all of that together and you can come up with some basis why the court requires the input of the DHCR, by all means, the court is entitled to do that. For example, there are times when sampling data is used, although I think that basically can be obtained pursuant to a subpoena. But if not, that might be a situation where the court could reach out to the DHCR. But I think that the current law now is that the tenant has the choice of form, and that has to be honored. With regard to the...
How would it operate if for some reason it wasn't the tenant who commenced an action?
Okay, so if the tenant did not commence the action, but the tenant counterclaimed in the action. That's not the case here, but I think it would operate the same. That if the tenant had a right to counterclaim, whether it would be in a housing court proceeding or Supreme Court action, I still think that the rule would be the same. I see no reason why it should not be. I would like to touch on the issue that I know council is going to address with regard to the applicability of the new law to this case, because it was dismissed. In case the court is not aware, there was a ruling by the appellate division in late November, a case called Zittman, which I can't find it at the moment, but it held that an action that had been dismissed by the Supreme Court for rent overcharge, that the HSTPA did apply because the appeal was pending at the time of the enactment, or at the time of the enactment of the HSTPA. And I submit that that's exactly what should be applied here. There is an appeal pending. There was an appeal pending as of June 14th, 2019. There's no reason why the HSTPA does not.
Pending as of the effective date?
Correct.
Is
maybe
that
you
a
could-
statutory argument or a constitutional argument?
It's a statutory argument. There's been no constitutional arguments made by counsel in this case. So
Maybe you
we
could
did not
clarify
address them either.
where you're at right now. As I understood, when this action was commenced, it was prior to the 2019 changes, as many of the other ones are. So the primary jurisdiction rules that were in place here would be the New York City rules as opposed to the outside of New York City rules. Is that correct?
That is correct, those rules were not codified. They were based upon decisions of this court as well as the appellate division and lower
So
courts.
the way I understood it then is that DHCR should have the power to enforce the Rent Stabilization Act, but there was no specific reference in the RSL to the choice of forum, and that the RSL, the Rent Stabilization Law, only applied to New York City. So it would seem that prior to then, at the time you filed, primary jurisdiction was in DHCR. Is that correct?
No, I don't accept that, Your Honor, because...
Tell me why not.
Because there's many decades of jurisprudence whereby tenants had the choice of forum, and that was honored. And even Thornton versus Barron, for example, other cases that were brought to this court, Coniston, there are many instances where the tenants were able to pursue their claims in court, and it was generally only if the landlord made a motion to dismiss, as was done in this case, that the court might dismiss on the basis of primary jurisdiction, although I would say that up until this case, that was not the norm, and that this case unleashed something about 24 or more cases that came in the wake of this case that were dismissed, which was, I think, what caused the legislature to act in the HSTPA. So the answer is no. There was a...
Do we know what DHCR's position is on whether it had exclusive jurisdiction or primary jurisdiction, or some kind of specialized technical knowledge or anything?
We do indeed. The DHCR submitted an amicus brief in this case, in which they argued that they do not have, the doctrine of primary jurisdiction does not apply here. They don't want all the cases. They don't have...
They have enough to keep them busy.
Their resources are too taxed.
Your adversaries
as it
say
is.
that they have a more streamlined process, and that's better for everyone.
They do not have a more streamlined process. They have the worst thing, well, there's many things about it, but in this case, the way this case originated is that 30 individuals from a particular building came to our firm.
So you can't
together.
jointly prosecute in
Correct.
the DHCR. You can't
can't
join
point
your
out-
resources.
you can't point
to
out
hire
similarities.
A tenant's firm. And the likelihood of inconsistent results is therefore increased when you have 30 litigations in the
Yes.
DHCR. So, I mean, those are some of the policy reasons why the legislature may have made the change that they did to make it express.
Yes.
But
You
so
can't
we're
depose
clear, though,
witnesses.
if we were to apply the HSTPA, your position is we don't need to wrestle with what the law was.
That's correct. I see that my time has expired. Are there more questions?
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors, and may it please the Court. I'm Adrienne Koch from Katsky Corins, here with my colleague Mark Walfish on behalf of the respondents. Let me start by talking about the statutory language subject to the tenant's choice of forum, because I think that that is the basis on which my adversary claims that the HSTPA completely abrogated the common law doctrine of primary jurisdiction. We submit that the addition of the phrase subject to the tenant's choice of forum after the specification of concurrent jurisdiction simply makes clear that the jurisdiction is concurrent but not simultaneous. That is, you only invoke the jurisdiction of one body or the other, but not both.
Then what does it mean, subject to the tenant's choice of forum? So that says that the tenant does have a choice, right? It contrasts to, for example, there's concurrent jurisdiction elsewhere in the various statutory schemes. For example, the family court and the criminal court have concurrent jurisdiction with respect to certain offenses, and the statutes there specify that there's concurrent jurisdiction, but invoking the jurisdiction of the family court does not divest the court of its jurisdiction. The two courts have jurisdiction at the same time, and the statutes provide for record sharing and the like. And so we submit that the addition here, subject to the tenant's choice of forum, simply distinguishes the kind of concurrent jurisdiction contemplated here from the kind of concurrent jurisdiction that exists in those other places. And I would respectfully remind the court that under this court's...
You're going to have to explain what you mean by that, because I didn't follow that at all, frankly.
Concurrent jurisdiction subject to the tenant's choice of forum simply means that once the tenant chooses the forum, the other forum doesn't also have jurisdiction at the same time. The family court...
Well, obviously you don't want to litigate in two different fora at the same time.
That's not my understanding of what happens in family court either, actually. You can't have the same claim in two different courts.
I mean, you choose.
Right, and once you choose, you're there and you're subject to all of the rules that apply in that court, which in the court, all of the rules that apply in that forum, which in the court
But then how did that change the prior law at all?
I'm sorry.
I mean, wasn't that true under the prior law too? So what's the change?
Under the prior law, the statutory language, and we discussed this in our brief, it suggested that in New York City, DHCR had exclusive jurisdiction, and the rule that DHCR has concurrent jurisdiction with the courts was a judge-made rule that's codified by the 2019 statute. We submit that a statute under this court's precedent, a statute should not be interpreted to abrogate the common law if it is subject to another interpretation that doesn't do so. There isn't a sufficiently clear expression of legislative intent to abrogate the common law doctrine of primary jurisdiction, and in fact, there's...
What kind of language would have been necessary, given the language that's used? Concurrent jurisdiction, subject to the tenant's choice. What else would the legislature have to have articulated?
It could have specifically said the doctrine of primary jurisdiction shall not apply. And there's nothing, not only...
It could have, but the question is, did it have to? I mean, I personally, I think your reading of this language is a little bit strained the other way, and assuming for the moment, and I don't know how any of us feels about this, that we think that that language indicates that the tenant's choice is given a preference, then how could that not act to affect the doctrine of primary jurisdiction?
I would respectfully, well, two things, if I may. One is, you need to look at the legislative history and what the legislature expressed that it was doing. There is nothing in the legislative history to indicate that the legislature even considered the doctrine of primary jurisdiction, nor that it even considered what the impact would be on the courts if it took away their discretion to dismiss cases in favor of DHCR. And one of the questions, I forget who asked, about getting the input of DHCR, the statute does allow for questions to be certified to DHCR and for DHCR to intervene, but only outside of New York City. When the legislature amended the statute in 2019, it did not give courts within New York City.
All it had to do then was add the same language as to New York City that it had as to outside New York City. They wouldn't have to come up with a whole new
But it didn't.
rule.
That it didn't, and what we say is that it, by not doing that, what it left in place was the way courts within New York City have to get the input of DHCR is primary jurisdiction.
Well, let me ask you this. Even if we apply the doctrine of primary jurisdiction, how the issues, some of the issues in this case are the very same issues that we've spent the last 2 hours hearing arguments on in 4 other cases, and I'm sure there are many more cases that aren't before us. And it seems to me that these are the very type of cases involving legal issues, involving interpretations of the law that that don't fall within the primary expertise or the specialized expertise of an agency. And in fact, the agency here says it doesn't, and it's contrary to the concurrent jurisdiction that has been exercised for many, many years in these cases. So even if we apply that, how would dismissal be proper here?
If I'm understanding your question correctly, and you'll stop me if I'm not, there is first of all, concurrent jurisdiction is one of the prerequisites for the primary jurisdiction doctrine to apply. So the primary jurisdiction doctrine applies here precisely because there's concurrent jurisdiction. And there is
I'm saying more than that. I'm saying that the courts have regularly and repeatedly tackled these very questions, and there's never been, and I think counsel stated that this is very, very unusual, actually. So how can you say that this is so uniquely within the agency's expertise, given these issues?
In the lower court, the plaintiffs didn't actually argue that this case raises any legal issues that hadn't previously been addressed by the courts. Their brief is attached as an addendum in our brief because we had some issues with whether certain things were preserved, and this is one of them. They, in fact, argued the opposite. We submit that that should be dispositive because, remember, the question here is whether the lower court correctly exercised its discretion under the doctrine of primary jurisdiction. Discretion implies that there's a broad range of things that could be within the realm of what's proper.
But the underlying justification for primary jurisdiction is what Judge Stein is asking you about, right? That the need to send it to another entity that has specialized, either has experience or specialized expertise, and that's what you're drawing on.
Correct. And in the lower court, we listed a number of reasons. Now, we submit that under the doctrine of primary jurisdiction, as it applies not just here, but in various areas where there's an agency, once it applies, you need a reason to keep it. And that's what the cases cited in our brief say. But
Okay, so how does just an overcharge case require the DHCR expertise? What is special about your case?
We gave a number of reasons in the lower court as to why dismissal was a proper exercise of jurisdiction of discretion here. There was, in fact, a proceeding pending in DHCR brought by some of these plaintiffs where DHCR was going to determine some of the very factual issues that the plaintiffs claimed were common to them. The plaintiffs argued that the calculation of their rent required a review of DHCR's own records going back 18 to 20 years. There's now an additional factor. The plaintiff's complaint cites the DHCR's own regulations and relies on DHCR's own regulations, which we submit DHCR should have the first crack at revising in light of the new statute. But the most important thing with respect to this, Your Honor, is that the plaintiffs didn't respond at all to the discretionary factors that we raised below and didn't raise any discretionary factors in their own argument. They only argued that the court didn't have any discretion.
If I may, because your white light is on,
Yes.
and I don't want you to run out of time before addressing the GBL issue. And I just want to be clear what your position is. Are you asserting that a tenant can never assert a 349 claim, or are you saying that this particular complaint, and I think it's in paragraph 31, is just too vague or insufficient to withstand a motion to dismiss?
Two answers to that question, Your Honor. The first is that we do claim GBL 349 doesn't create a separate and additional right of action every time someone violates a statute and doesn't announce that they're doing so. And that's what this court held in the Schlesinger case that's cited in our briefs that neither the plaintiffs nor any of their amici address. The plaintiff's position here would mean that every rent overcharge claim is necessarily also a GBL 349 claim, and that makes no sense. And if the legislature had intended that, we submit that
Let's say, hypothetically, a landlord thinks that they have properly deregulated this building, or it's not subject to rent stabilization, and they send out ads over whether it's the internet or, however they advertise, come look at our, no broker, no fee, come to our rental office, you can get this market rate apartment, fabulous views, etc. That's not going to fall under the GBL, and it turns out that that's incorrect, all right? They should have been regulated. Would
But-
that be subject to the GBL?
From what you have said in your hypothetical, I would say no, and the reason is because for a GBL 349 claim to exist, not only does there have to have been deception, but the plaintiff has to have been damaged by the deception. And there is nothing in the plaintiff's complaint, and the plaintiffs haven't said anything in their briefs to say
What
how
I'm trying to distinguish here is not so much this complaint, which I'm going to ask him when he stands up on rebuttal, is focused purely on that one sentence in paragraph 31. What I'm trying to get at is, are you saying that categorically there can be no 349 claims based on some sort of misleading representation on as to the rent stabilized status, or it's just not pled here?
Well, I'm saying both. I only need to say it's not pled here, but in your hypothetical, I do not see how your hypothetical plaintiff is injured by deception. They got what they thought was a market rate apartment, and it turns out that it's rent stabilized. If they can show some injury that a market rate apartment would have been better for them than a rent stabilized apartment, or that they entered into their lease thinking they were getting a market rate apartment and now they're embarrassed to find out they have a rent stabilized apartment.
But what if they later find out that it should have been rent regulated and they should have paid less rent for this very apartment?
And what they are damaged by is the violation of the rent stabilization law, which provides them with a complete remedy. It has nothing to do with deception. It's a violation of the rent stabilization law, so their rent should have been lower than it was, and they get damages for that. But what injures them is the violation of the statute, of the other statutory scheme, not deception.
Could there be a violation of both?
I'm sorry.
In this hypothetical,
Could you
I would say-
violate, could you violate the RSL by deception?
I don't want to say categorically no, because there may be situations where the wrong is deception and it violates both. But in Judge Feynman's hypothetical and in this case, that's not the case. The other thing that I would point out.
Be clear then, you're not seeking a per se rule that a tenant could never assert a Section 349 claim.
A tenant might. a tenant might have a separate claim for damages that arise from deception, but they would have to be separate from the damages that arise from violation of the RSL. The other thing I would point out is that in 2019, when the legislature amended not only the RSL, but also the general business law, because the HSTPA has amendments to the GBL in it as well, they did not see fit to say anything about this issue, even though courts had been regularly dismissing GBL 349 claims under this very context. So the legislature, by its failure to act, put its imprimatur on that result. I see that my time is up. The only thing I want to add is that the statute's very clear in saying it applies to claims pending or filed on and after the effective date. Doesn't say cases or actions or proceedings the way the 1997 amendments did, which are referenced no fewer than 6 times in the HSTPA. The plaintiff's claims in this case were not pending on the date the new statute was enacted because they had already been dismissed. If they had been pending, this court wouldn't have jurisdiction.
Is there ever a determination as to the substantive issues, the substantive rights of the tenants here, ever?
No.
Okay, so it was dismissed so that those issues could be determined, the merits of those issues could be determined in another forum,
Correct. Yes.
Okay, so you think that the legislature wouldn't have intended to include such claims in the new statute?
I think the legislature very clearly said claims and not actions or proceedings. And under the rules about statutory interpretation, the court is bound to give effect to that distinction. The only way to give effect to that distinction is to treat claims that have been dismissed as not pending, even though the action or the proceeding is, of course, still pending.
Thank you, counsel.
Thank you.
Mr. Langendock?
Yes, thank you.
Can I just start with that
Yes.
point? What, if any, significance do you give to the distinction in the language?
Your Honor, I give no significance to
Why
that
not? Why
whatsoever.
shouldn't we?
Because there's no difference in the definition in this context between claims on the one hand and actions and proceedings on the other hand. There's no cases that are cited anywhere that point to any difference. In fact, I would argue that the term claims is broader than the term actions and proceedings. If you look at the dictionary, can encompass, the term claim could encompass more than an action and proceeding.
Counsel, can I ask you something? I think the
Sure.
reverse of what I think Judge Feinman asked you before. If we find this was an abuse of discretion to invoke this doctrine and reverse on that basis, do we need to get into whether or not the new law applies?
Right. I was waiting for somebody to ask me that question.
Glad to indulge, yeah.
And thank you for asking it. And the answer is no. You could decide that, for example, this court is not going to reach the issue of the applicability of the HSTPA to this action. But
Because even under the prior law, if we were to decide that, even under the prior law, it was an abuse of discretion.
that is possible that you could do that. If I could very quickly, the site for the Zittman case is 177 AD 3rd 565. And in terms of the GBL, if I could just have a second to address that.
So all you have is paragraph 31, right?
Excuse me? Of my complaint?
The only thing that's relevant to that, that's in your complaint, unless I missed something, is paragraph 31 at record page 15, or page 5 of your complaint.
I don't think that's correct, Your Honor. I think, first of all...
So what else is there?
Pardon me?
What else is there?
Well, the complaint is replete with allegations that the plaintiffs were rented apartments that were represented to them to be market apartments and that were charged illegal rents. And then the complaint goes on to allege that these were consumer-related activities that were aimed at the public at large and that the plaintiffs were injured.
See, so
as a
that's what I was
result.
looking at, was, what I was trying to find is allegations that go towards what was represented to the public as opposed to these individual litigants
So
or individual tenants.
the allegations in the complaint are simply that these facts were represented to the public, or that they aimed at that the conduct was aimed at the public at large, and that it was deceptive. And I would say that
I
that's
guess the trouble
sufficient.
that I'm having is just the language seems pretty conclusory and just sort of a broad
I think
statement.
I think it satisfies the 3211A standard, and I think that, we would await the discovery process. I think that almost by definition, landlord-tenant contracts or landlord-tenant arrangements are consumer activities, and that the GBL prohibits deceptive business practices.
Well,
That's
how
what
did the
we're
landlord
alleging.
solicit tenants?
Excuse me?
How did the landlord solicit tenants? Is that anywhere in the complaint?
The complaint, I don't know if the word solicitance is there. I think it says that the actions were consumer-based and they were directed at the public at large, and they
Weren't
were
you-
deceptive.
When you read the allegations of the complaint, aren't they essentially saying that these were not represented to be rent-regulated apartments?
Right, that's the point I was getting at, was
Okay,
that
so,
taken as a
so what you're
whole.
saying is that they were violating the rent stabilization law, right? And they didn't tell you that they were violating the rent stabilization law. Isn't that the essence of what you're alleging here?
Yes, but also that they were violating the general business law, because they.
Right, but doesn't Schlesinger address that and say that that's not enough to
No, I
find a
don't think it
violation
does.
of
I
the
think
GBL?
that, I think that, first of all, by its own terms, the GBL it can be an additive claim. It can be overlapping. You can claim both. Secondly, there might be times when there's a violation of the GBL, but not the RSL or one or the other. In this case, I think that, the complaint as a whole satisfies the requisite standards for setting forth a cause of action under the GBL. I would also note that a number of amici, got together to submit a brief to this court in which they pointed out cases such as the purchase of a dog, purchase of insurance policy, entering into a mortgage agreement, an equipment lease, and other things that are clearly within the ambit of the GBL, and I would submit that.
Is a difference
This-
because it's a regulated market?
No, there's not, because a lot of these other matters involve regulated markets as well.
But that's what I'm saying, this is also a regulated
This
market.
is also a
That's my point.
regulated market. Right. So we're entitled to seek relief under both statutes, the RSL and the GBL.
Thank you, counsel.